maybe there's some public comment. Hello and welcome to a meeting of the California Paraprofessional Program Working Group Regulation Subcommittee. You can start by taking roll. I think Amos is not with us yet. Kirkmeyer?
Here.
And Sarush?
Here.
And I can see, it looks like there are a number of members of the public. Let's see if anyone is interested in making any comment. So we have a number of members of the public. If anyone is interested in making comment, please raise your hand. And maybe we can do that. I can just show really quickly what we're going to be discussing today, and we can go back to see if anyone wants to make any comment. If that makes sense. So let me go ahead and share this very can everyone see this? The PowerPoint slideshow?
Yes, I can.
Okay, Amos is here now. Great. Hi, Amos.
Sorry I'm late. Hello.
That's okay. We're just getting started. And these are the topics that we're going to cover today. So what we've got is the rules of professional conduct, and I have some slides that I've prepared to review that that will be used at the meeting on Monday, and I think we can use today's meeting to sort of fine-tune them and to discuss how that presentation is going to go. We also are bringing back to this subcommittee, at the request of some of the members, a revised version of the structure for the licensing and oversight committee, as well as the paraprofessional license name. We want to get your input on that. Those are going to be staff recommendations. So this isn't going to go, those two items aren't going to go back to the full working group, but I know that the regulation subcommittee wanted to provide your input on those two topics. And then finally, Brady is here and he's going to go over the last few items on the policy review that he didn't complete at the meeting on June 25th. Okay. So just with that in mind, I want to go back and see if anyone wants to make any public comment. And if so, raise your hand. Okay, I don't see any hands. So I will go ahead and show you what I've got in mind for the slideshow. So I think the plan for Monday is to start out with the group vote on the rules that are identified as group vote in that table that Andrew created. And obviously we will invite members, if anyone wants to bring any of the rules that are on the group vote list for an individual vote, then they will be allowed, invited to do so. And then we'll, after we have the vote on all of the rules, and then we'll turn to the individual rules that require separate votes. And what I've created is, it's kind of an abbreviated version of the table that was created. So I sort of truncated some of the language, because some of the language in the memo and in the table had more details about specific rule numbers and subdivisions. So here we have just like a high level summary. So I just want to ask the subcommittee how you want to go about presenting. I think in some cases there was disagreement about what the rule that should be presented. There wasn't necessarily consensus. So maybe we can talk about how we want to do this presentation. And I'll just show you, there's one more slide. There were a total of 9 rules that were brought up for separate vote. Does anybody want to start off a discussion about this?
I think there's only one area of disagreement, and I don't even know if that's too much. I mean, too large. It's only just the one area of putting information in about information to individuals if they have to basically not represent this individual. Different alternatives. I think that's the only thing we disagree on, right, Fariba and Amos? That's.
Are you talking about resource information?
Yeah. Mm-hmm.
Yeah, I think so. I think I'm still in the position that there should be no requirement. The default position should be just in general provide information, and every subgroup committee can come up. Each subcommittee can come up with their own requirements, if not default. But in general, it should be just a general notice.
Okay.
So I think that's right, Kim, that I think the three of us are in agreement on everything but that. And it might be worth a few minutes, although we've probably kicked that horse a few times. One more shot to see if we can get all on one page, because I would love for us to have a joint recommendation for everything. As far as I think what Linda's asking is just how are we going to present on everything? We're in agreement on everything. Just how is this going to unfold on the 26th? So just putting a pin in that one issue for a second. I would like to take a chance to review these slides, at least for the ones I'm presenting on. I might have some minor edits. I'm sure it's nothing major, but I think what we've discussed is that we split up who's presenting on each of these rules. And I think we could do it with these slides as you've created them, Linda. I think that's fine. It might make sense if I could recommend that we send out one more email to the full working group to let them know that we are planning on a group vote as referenced in that chart, and that they will have the opportunity to identify individual rules if necessary, just so everyone has plenty of opportunity to look at them and to decide. But hopefully most of them will go through the group vote. And then it's going to be, I think for the individual votes, we've already split it up. So probably it makes sense for me to go first if we're just starting in this order of the rules.
And if you want to do edits, I think what I'm going to do is take it out of this display version so that I can edit as we're reviewing it. Does that make sense?
Yeah, you want to go through it right now? I think that's great.
Sure. I think that's a good idea.
So I'm fine with the 1.4.2. I would, for 1.4.3, I would suggest deleting. So paraprofessionals will be required to obtain the prospective client's informed written consent. I would delete after consultation, comma, tailored to the facts of the case, but, so it just says prior to representation.
Yeah, that was your original version. That what you want to eliminate is what I added.
Oh, got it.
Because I just thought that it makes it clear why we have different ones at what stage. So you do say prior to consultation, prior to representation, and I thought it's important to say, but it's the difference is that now it's tailor-made, it's specific to the facts of the case, and that's what an informed consent is and how it's different from the notice to consumers.
So
we just have too many notices.
And just so you know, that's the language that was in the table in the memo that was posted to the website. So maybe just having the more abbreviated language for the PowerPoint makes sense.
yeah, and Fariba, I don't disagree with anything you're saying. I think that makes a lot of sense. I think leaving it like this, the simple version, and we're just gonna have to talk through what informed written consent means. In reality, these might happen at the same time. So we just have to realize, I don't think we want to require there to be like a time period between the notices, because it could be somebody walks into an office and takes care of it all in the same few minutes. And so I don't want us to suggest that there has to be, a cool off period or something in between them.
Not at all, but how could it happen at the same time when somebody walks in and the paraprofessional doesn't know the facts of the case, couldn't do an informed consent without spending a little bit of time interviewing, triaging the person, yeah?
So if somebody walks into a family law paraprofessional's office and says, I have a custody dispute, can you help me? I have a hearing coming up and I need to file something, can you help me? Probably what's going to happen is the notice right away, and then they'll talk about the case, and then they'll sign a retainer agreement, right? So what I'm saying is it could all happen in one session. It doesn't have to be a phone call. It doesn't have to be a
Sure.
time between them. You know, somebody comes in and they leave the office with the engagement agreement signed. But the paraprofessional will have to meet all of that person's required disclosures, but it's not, we are sometimes saying, okay, there's an initial conversation, and then there's time, and then there's a later conversation, and it doesn't always have to happen that way.
I didn't think it communicated all that, but okay. I don't want to hold us up.
But I think the discussion points you raised are exactly right. And I do think the full working group might be where we were earlier, which is 3 written requirements too much? Can we simplify? And we'll just have to explain. Sorry for the long, okay. Let me review more. I think 1.5 is fine. So all of the rest are fine with me. For 1.5.1, are we still planning on having 2 versions for a vote?
We have the versions that were included in the memo. I think there was just one. But it could be that, you know, we can present one, and I have prepared what was in the memo. I have prepared to share that. And if after discussion, people want to modify it, that can happen. But I think that it makes sense to vote on one version. And then if there's not, you know, if that version doesn't get approved, then we can turn to a different version. Or one version can be, someone can move to adopt one version, and then during the discussion, it can be amended before the vote.
So I think what we discussed, I think we can decide on any way forward we want, but I think what we proposed is that for 2 rules, 1.5.1 fee sharing and 5.4 ownership of law firms, that it's a very significant split in opinion, and it's very controversial, and we should have 2 versions of those rules. Hopefully we will move in the version that the 3 of us are proposing, and hopefully that gets passed. But I think we do want to be prepared to potentially vote on an alternative version of those. And since there are multiple possible alternatives, I think it makes sense for us to have draft language ready on the proposed alternate resolutions, because there are multiple options. And I think what we decided is for fee sharing that there would be no fee sharing, as opposed to following the attorney rule, which is different. And for 5.4 ownership of law firms, that there would be no ownership allowed for, as an alternative proposal, no ownership where attorneys are owners or employees. So Greg, is that something that we have prepared, or do you need help preparing those alternate possible resolutions?
I have not prepared alternate resolutions, but Steve Fleshman has prepared alternate resolutions for both of those contingencies. So I think it could be as easy as just taking what Steve has already provided through the comment he's provided to the subcommittee and having those alternatives ready. So if staff could just have that prepared, we could have that as an alternative in the event that the working group doesn't go along with the subcommittee's recommendation.
Okay, I can do that. I can prepare
Everything
something
I
based on
said.
what Steve provided.
But we're just going to include what we're proposing, right? as
I
res-
think when I review these proposals, I will certainly make clear what the three of us recommend. But for those two, I think we are going to say, we've heard back from the full working group and public comments that these are very controversial, and we have, thought about what an alternative would look like. And so to say that, but that the three of us, are consistent in what we recommend.
So are you presenting 1.5.1?
I think so.
That was a minus, but hey, take it all. I'll just watch.
So I'll go back and look. So I know I'm doing 1.4.2 and 1.4.3.
And you're doing 1.5.2.
Yeah.
Yeah, I thought you were doing those three.
Yeah. So that's fine with me. So then what I just said is a recommendation for you, Fariba, if you're presenting on those. But I think that's what we discussed, is the three of us are in agreement, but that we've heard very loudly that these are controversial, and we've thought about it and considered it. And this, we have prepared if people want to consider an alternative.
And we're going to be making the motion, right? Each one, whoever's presenting it potentially.
So maybe that's something to discuss on how that'll work. But I think it certainly would be preferred for us if the one that we recommend is the first motion, but I don't know that we can guarantee it unless we make the motion.
Yeah, something that's really kind of confusing with these meetings is that, I'm used to just, making the motion, somebody seconds it, then you have discussion. But people want to start discussion beforehand, and I don't know, half of the time I don't have an idea where we are. So, and the thing is that the chair has an idea about how she wants to do this, and it gets really confusing. When I'd rather be told ahead of time, like for something like this that's controversial, open it up for discussion first, or whatever, however the chair wants to do it, or you guys want to do it, I don't mind. But I don't want to start presenting and then be interrupted and be told I'm not doing it right. It's just really confusing and disturbing. My apologies for mentioning it, but this is where I want to get.
So this, Fariba, this is, and I apologize, I'm in a public space, which is
Hi.
why I'm muted and not on video. But I think as a general matter, we should simply have someone move and then have discussion, because otherwise what tends to happen is that there's so many modifications that it's like we're having an ongoing discussion about various versions of
Right.
a proposal. And so I think, and I'm just going to say it now, and I'll try to remember to say it when we're in the full group, we're better off if we have someone moving, move it. If there's a second, and then we can have discussion. And the discussion might lead to a conclusion that, a minor modification would lead to group consensus. But I think it's smoother that way.
Okay, I agree with that. Yes, absolutely. And then if there's discussion and then there are changes made, we could do that, ask for a friendly amendment. If not, we take a vote, and if it's, it doesn't move, then we'll come up with the alternates. We'll take a look at alternates. Somebody will propose, move for an alternate. What do you think about that, Amos?
Sounds great. And Linda, I'm fine with all the rest on this page. Do you mind switching the page to the next?
And just one question, rather than issue here, do we want to say, have this column entitled Regulation Subcommittee Recommendation? Or is it fine the way that it is?
Or maybe just summary?
Okay,
Yeah, summary would be better.
okay.
So I think that 1.5.1 is the only one that's controversial in terms of what we're expecting. The other one I'm doing is 5.4. I think that one is also controversial, yeah?
Could be.
Yeah, but I think this summary looks great. I think for 5.3.1, sorry, I forget who's presenting on that one. Is
I
that
think it's
you?
Kimberly.
Maybe it might help to put something in this summary that shows that it tracks the rule for attorneys.
That it's the same.
Yeah, these look great. Thank you for putting that together, Linda. I think this will be
Sure.
very helpful.
Okay, great. So it sounds like we're ready with that for the meeting. So then the next topic, again, where we want to get input
Hey,
from
Linda,
this.
I'm sorry.
Yes.
Can we go back to that chart just real quick?
Mhm.
Up one more. It might be good to move 1.5.2. I know it's completely out of numerical order, but it might be good to move it up to where they are grouped, the way they're going to be presented together. Because Amos, you're going to do all of them kind of together, right? It makes sense to do all of those written agreements together.
So do you all have a preference? Because I'm fine doing it in this order. The order of the rules, which kind of makes more sense to me.
Okay.
And just us going out of order, so I can just come back in after. But if you have a preference, I'm fine either way.
I actually agree with Kimberly. I do agree going in numerical order makes sense, but in this situation, you get three written, well, you get the notice, the informed consent and written agreement that go together. One is at the start, one after you get the facts before representation, one to start representation. So I would agree that they should be put together, but
Okay, I'll defer to the group. I'm happy to do that.
Okay, and I don't have to do that right now. I've just made a note. So you want to move that up after 1.4.3?
And before we move on, can we do one more? Well, this is going to take, I'll try to keep it to 5 minutes or less on 1.4.2. So the point that you mentioned earlier, Kim, the one disagreement. I think it would be great if we all had consensus one way or the other. And the issue, as I see it, is this. So this is just for, oh, I'm sorry, this is 1.4.3, informed written consent prior to representation. So the issue is, paraprofessional now has done a consultation. They know the facts. They're giving a disclosure to get informed consent to the representation about risks and alternatives. And in particular, for low-income individuals that may qualify for free legal services, including potentially a free attorney, what that disclosure should look like. Now, it might be that that detail doesn't need to be in the rules of professional conduct, or it goes in examples or comments or trainings. But the bottom line is, for it to be meaningful and useful, for somebody who is potentially eligible to get a free attorney, it doesn't help to have a standardized disclosure. Legal aid exists, so you might qualify for free legal services. I think to be meaningful, it needs to be like, I can help you with this, but you should know there are alternatives available. And given your income, or given that you're, receiving public benefits, you may qualify for free legal services. In our county, here's the service provider that provides it, or something like that. If it doesn't look like that, and it's, I see you're low income, you're on benefits, you should know legal aid exists and you might qualify. I just don't know how useful that is. So I'm interested in your thoughts. In the housing subcommittee, where we were specifically talking about, shortened timelines, the need to hire an attorney when there's, subsidized housing, so it's public benefits at issue. It was specifically discussed that, yeah, it's not enough to say you might be eligible. It's like, this is a serious issue. You could lose your housing. there are free legal aid services, and these are, here's their contact information. And I think Fariba, in that context, you agreed that that was appropriate. So I guess the question to you, I just want to propose, I guess, one last time is, my concern is just a generalized legal aid exists, you might qualify, is not what's appropriate here. The real informed consent is, given your income level, you might qualify for a free attorney. Here, here's information about what's available in our county. So interested in your final thoughts.
So I'm still struggling with why should we put this weight on the shoulder of paraprofessionals? Why are they responsible to connect this person with specific resources? Why is it not the responsibility of the client to find their own specific resources? It's a great practice, best practice, but why are we making it the disciplinary rule?
So it's just an informed consent. So for somebody to be able to make the decision, they need to, they might, so if I'm putting myself in the consumer's shoes, I might want to investigate. You're exactly right. What, am I eligible for a free attorney before I sign this agreement? But what hoops do I need to jump through to figure that out? And so a paraprofessional, it's going to be a standardized disclosure, right? They're going to know what county they work in, what practice area they work in, and what legal services are available. So it's not going to be a huge burden for the paraprofessional. I mean, maybe the first time they might need to do a little research, but they're not going to need to do research every time somebody walks in their door. It's a matter of, you're right, burden shifting a bit, right? Providing information. The paraprofessional has, the potential client does not have. So, if a family law issue comes in, that they may be eligible for a free attorney, and the paraprofessional knows that 2 doors down, they just call that number and they'll get a free attorney. Does a paraprofessional need to tell them? That's the question. Or can they just say, legal aid is something that exists in the United States, and you might be eligible. Or should they say, 2 doors down, give them a call, you could get a free attorney for this. And again, I don't think it needs to be overburdensome. I think just like in the housing practice area, we had the same discussion. It is, should the paraprofessional just have a short list of the 2 or 3 legal services in their county that practice this area that they can give the person who may qualify.
The housing area has shorter timelines, and that's why, when they have 5 days to respond. So it's often that we get people here on their last day, where, for example, in the area of family, you often don't have such quick turnaround. So the client has more time to research. And again, I think it's best practice. It's just, I'm still wondering why it's a disciplinary rule. I think that part is unfair. I think Kimberly wants to say something, so sorry, I interrupted you.
No, you're fine, Fareed, but I completely agree with Fareed. That's where I am, is that I think the way we have it worded right now, with you have to provide quite a few alternatives, right? That this person might be available. It's the contact information and holding this person responsible to having a specific list. What if that number's wrong? And then that basically, I believe, could be potential, you give them wrong information, that potentially could be something that they would get in trouble for. And everything you say, Amos, that they should have a list with the counties and where it's available, and here's all of the numbers. That's what I truly think is the best practice, and that's what they should be doing. And I think we kind of heard that that's what they do, but I would hate to put it into where if they haven't, they gave a wrong number or they didn't have specifically everything there, that they would get in trouble for that. That's where I'm coming from.
Okay, so thank you for letting me make my pitch one more time. What I'm going to suggest is that we go with the version that you two suggest. So we just have one version of this rule. And again, maybe if there's a friendly amendment or maybe if there's some discussion of this at the role, but I prefer that we just have one proposal for discussion. Does that work?
I think that's what's in there now. Is that, I'm looking at the one that's the section. I think that's there now.
Oh, good. Okay, I thought there was the comment that we had a split recommendation on this. Okay, great. Thank you.
Okay, are we ready to talk about the licensing and oversight committee? I'll go ahead and share my screen again.
I just need to apologize to everyone. I mentioned early on, I unfortunately have to jump off because I am dealing with a emergency writ petition. So I will try to catch up through the video later, and please feel free to email me if you have any questions between now and Monday. All right.
Thanks, Greg.
Thank you, Greg.
Thank you. So what, can everyone see this screen now? The oversight committee chart. So what I've presented here is the initial recommendation that was provided in December, and then a revised recommendation. And that was partly based, and I discussed this at the June 25th meeting, it was partly based on feedback from some of the members of the working group that the size should be smaller, as well as looking at the policy adopted by the Board of Trustees. But the feedback that we got at the June 25th meeting is that we really need to go back to having a 13-member oversight committee. We did add a judge and then clarified that the paraprofessional educator should not be an attorney or a paraprofessional. So that's what's here. But other than that, I'll just give you a minute to look at the current idea that we have and see what you think.
To me, the revised one is better than what it was because it has 3 paraprofessionals now. So you have more representation from the paraprofessionals versus just the one individual.
So I agree. The original proposal was 5. What do you think of the number, Kim, of paraprofessionals?
I actually think you should take 1 attorney away and add it as 1 professional. So you'd have 1 judge, 1 attorney, 4 paraprofessionals, and then 6 public and a paraprofessional educator. Because it is the paraprofessional, whatever it's going to be called, oversight committee.
Has there been any thought given to having a self-help center, family law facilitator, self-help center attorney, family law facilitator on the committee? Because we're like one step closer to SRL issues and the challenges they deal with versus a practicing attorney. And is there any value to, creating a separate category of those attorneys rather than just have a general 2-attorney category?
Fariba, is your concern that that wouldn't fit in either the attorney, paraprofessionals, or public members, and there would need to be a separate category for that? Because I think that could be captured in what exists. They would just fit into they could be appointed to the appropriate position.
So if I'm understanding this correctly, 2 attorneys is not necessarily, there's an option, right? They could just appoint 2 attorneys. Neither of them are self-help or family law facilitator. I was wondering, I don't remember if there was a discussion, my apologies, previously, but I wanted to ask you to, or whoever's here and wants to make a comment, whether you see a value in having somebody like that on the oversight committee, and do we want to create a separate category to ensure that, a person like that is appointed?
I think it could be very helpful. I mean, diversity on these boards of different perspectives is very important. It's just a question of do we have a mandated seat for that? And I don't know if there's anything similar on other boards. Kim, you might know that.
Yeah, there is, like for some of, like contractor state license board, you might have contractors, but they're in different specialties basically, or like pharmacies, we have like community pharmacists versus a retail pharmacist, even though they all have to be pharmacists, so they're a licensee, but they have them in different categories, and then they have to meet that.
Mhm.
So here, for me, that would be similar to the paraprofessionals needing to represent the different practice areas, because it may be very different for housing versus family law. You know, again, I don't know that we need to do that, and I don't, you know, hopefully this will be expanded to other practice areas, and I don't know that we're going to want to have every practice area, but I agree that probably there should be more paraprofessionals on this board, at least.
No, I think that's a great point as well, that, you know, my guess is most of the work is going to be in family law. So there should at least be a paraprofessional that represents that specialty. And along the lines of, you know, self-help attorneys, family law facilitators, working with all SRLs and so having that kind of expertise of the issues SRLs deal with would be helpful on this, as well as legal aid attorneys, or just legal services professionals that also deal with a lot of SRLs. I just think there should be that specialty addressed here, rather than just the general category of two attorneys.
So can I suggest there is asterisks on a couple of these? Maybe what we do is we put another asterisk to say, consider diversity of practice area, or have that as a consideration, and just have really the appointing authority get to make the final decision on that. But I agree that should be the consideration, or those considerations make sense to me.
Me too. Yeah.
Yeah.
So Linda, did you capture that recommendation?
Yes.
Okay.
Did.
And for the number of paraprofessionals, I agree that I would like to see it be 4 or 5. I think the original proposal, oh, it's over here on the left, was 5. I think I would be comfortable with 4. I think 3 just seems
Okay.
too small. What do you guys
So-
think?
Completely agree. Yeah. I mean, you almost have to have a uneven number, right? Because you don't want to split vote. So that causes a little bit. So it's almost like when you add, you have to add 2 usually, or take 1 away. So that's the only, so we either take 1 attorney away, or
I agree. So I was thinking add a paraprofessional and remove one of the others, and to keep the board, the oversight committee the same number.
So if we have 1 attorney and 4 paraprofessionals, that's what Kim, you had originally proposed.
Maybe it would be better to have 5 public members instead of 6.
There's just a concern, I think the bar is trying to move towards having more public members than licensees on these oversight boards and oversight committees
Got it.
as a policy issue.
yeah, we're also definitely, the legislature's looking at for our boards too.
But there still would be, because of well, I guess the paraprofessional educator. Sorry, what is contemplated there? Is that that wouldn't really be a public, because they're obviously in the know in the industry, right?
Is there a concern about having just 1 attorney?
What was your question, Linda?
I'm just wondering if there's a concern about having just 1 attorney. one attorney and 4 paraprofessionals, and then leaving everything the same.
Linda, did you say the proposal is 13? Because right now I think it adds up to 12.
3. No, it's 1 judge.
Oh, got it. Yeah.
Right.
13.
It's 13 right now.
And the judge is an attorney too. I mean, I know they'll be, you know, have a view depending on where they're practicing, but. I guess the problem we'd run into if you remove public is, yeah, you wouldn't be as close to that. Almost the same majority for public members and licensees.
Yeah, I think if we need to have that many members of the public on here, you know, I wouldn't want to, I think having attorneys on there is valuable. As my only issue is that they have to be attorneys that understands the issue facing SRLs and paraprofessionals, and they're, you know, how they have to work and things like that. And want to make sure the attorneys that are appointed, you know, have that sort of, they're informed about those issues. So if we can't take away from the members of the public, I think this works.
Yeah, I certainly like this better. I think this is much improved. So I think I'm totally in agreement with this proposal. I think the only issue is this 3 or 4 paraprofessionals. So maybe Kim, you have the final recommendation on that.
It's hard because, you know, the only thing really in just looking at it to recommend would be to move one of the attorneys and make that a paraprofessional. And you do, though, have that other paraprofessional educator. So in essence, you kind of do have 4 individuals who have that knowledge of paraprofessional, you know, that license and what they're going to be doing. So you kind of do have somewhat of a majority of those individuals in that mindset, voting and making decisions.
I agree, although that paraprofessional educator is probably either an attorney or a paraprofessional.
That's true. That's right. Yeah.
But I'm okay with this recommendation, and thank you, Linda, for.
So you're okay with it as it stands and not, okay.
Yeah, and thank you for taking a critical look at this again. I think this is really important.
Okay, great, thank you. So then turning to the issue of the licensee name, I want to sort of take up where the discussion was happening at the June 25th meeting. Justice Petru presented this really well, and I don't know if you're available to talk about it anymore today, Justice Petru, but what we talked about was taking the 3 top names from the survey. But during that discussion, there were some serious concerns raised. Amos, you had some concerns. There were concerns about the translation into other languages, and so the idea of licensed, which had been very favorably looked upon in light of how that translates into Spanish. I think that was sort of taken off the table. There was concerns about these different acronyms that would result based on the choice of names. And then I indicated, you know, Amos, you had come up with this limited, and you liked the idea of using the term professional or advocate. And we wanted to take out the term certified and licensed. So again, so Justice Petru, it looks like you've unmuted yourself. So I'll stop.
No, I have. No, but you can keep going. I'll interrupt if I, you know, don't agree with anything I hear.
Okay, so we wanted to just bring this back to your subcommittee to get some more input. And then the idea that we have is to go back now to some professional translators in, you know, Spanish language translators, but I think also the other major languages in California, to see if there are any concerns identified based on the names that are selected. But we do want to get this subcommittee's recommendations about which names we should bring forward and sort of move to that next step.
Well, and I think in order to do that, we're going to give you, I think it was 3 names. I'm trying to find, Leah's not on this call, is she?
No, she's at the board meeting today.
Okay, yeah, because she and I were emailing about this earlier today. So I'm gonna say hold on this for a moment, other than to say that we are gonna come back to you probably with a short list and ask for your input on it.
That's great. We really appreciate it. And I assume the 3 names are not the ones that are on the screen. It's a different 3.
I can't see what's on the screen right now, so I couldn't tell you.
Oh, so what we included on in here was the top 3 names that came from this survey: the limited licensed legal practitioner, the certified legal practitioner, and the licensed legal advisor. And I think we
Okay.
do need to take out licensed. But then Amos had a number of names that you preferred at that meeting.
Well, but then there was not a consensus. I mean, that's the thing.
Right.
We're really not going to get to consensus on this. And so I would like input from this group, but I'm pretty clear that we're not passing one name on to the state bar. We are going to give them some choices along with the rationales behind it and the concerns that were raised.
That sounds great. So we appreciate that you're going to run those by us and at least include our feedback, either to modify the list or at least to pass on our feedback.
Yeah, and it may still be those 3. I just can't, I'm trying to, walk, talk, chew gum, and look at 2 screens at the same time. So it's beyond my capacity.
Okay.
I know that Amos had concerns with the certified. I definitely have concerns with the certified, because that's really not what they are. And usually that means something, definitely.
Yeah, and I had brought up the point that we've, in this committee and in all the notices, we talk about how to make it clear that I'm not an attorney. I'm not an attorney. So
yeah, and I will just say I have seen Linda. Linda took notes of everyone's concerns, and has a summary of those.
Yes, I see that on the screen. Yeah, I was just going to say I should have checked with our interpreter to see how that translates.
Well, we're going to do that. We're going to be doing that.
Yeah, I don't know if that's easily translated. Non-attorney.
This sounds great. We appreciate it. So if you could let us know what the sort of 3 that are currently being considered move on, I'd love to know that and provide some feedback, or for the 3 of us to provide some feedback.
Yeah.
Agreed. Yes, thank you.
Great. So finally, we're going to turn to Brady, who's going to go over these last few policy questions that we didn't get to at the June 25th meeting.
Sure, and I'll be getting to some of them. Just a little update on the MCLE activities. I've spoken with the BARC staff who are responsible for the process for approving attorney licensee credit for unpre-approved MCLE activities under State Bar Rule 2.86, and they're gathering some quantitative information and sort of a description of the process. But the initial overview I was able to get is that it is time-consuming, and that it chiefly involves out-of-state activities. And I've asked for some clarification on that, whether it includes, whether that means licensees who live out of state and are seeking their MCLEs out of state, or whether it also or primarily includes California-based attorneys who are traveling for legal education. But hopefully we'll have some more information. I've asked for it by next week, and it sounds like this is going to be, the information is going to be going in the direction of not, at least at the outset, recommending a process for paraprofessional licensees to get credit for unpre-approved CLE activities. Of course, this is a California program, and we don't anticipate having California licensees practicing elsewhere, because they wouldn't be allowed to. Our thrust so far is to have tighter control over these CLE activities for the paraprofessionals than perhaps we have for attorneys, given the newness of the program and the public protection concerns. Additionally, I was told it's a very time-intensive process to review these applications for credit, and I've asked for some quantification on that. given that one of our initial concerns in highlighting this as a potential issue was that it might not be worth the administrative burden. So we'll have more on that next week.
That sounds great. Brady, I'll just note that I think it might be very helpful for paraprofessionals, whatever they're called, in other states to provide some trainings of what they've experienced or what they've done. But I assume that could be done through a California MCLE provider or something like that.
Right. And as I understand it, there's nothing that would prevent an out-of-state provider from getting certification in California, at least under the current CLA rules. It's just, you know,
Right.
the standard is you design a course and you apply to us for credit and then you get it. And this rule allows attorney licensees to take any old course and then try to argue that they should get CLA credit for it.
So a California MCLE provider, for example, could have a panelist that is a paraprofessional in another state, and that doesn't. Great.
Sure. The next, and this is the probably the one where we should have the most discussion, is whether the statute of limitations provision for attorneys, and that's Civil Procedure Code 340.6, should also apply to claims against paraprofessionals. Let me share my screen here. The button sometimes disappears depending on what, here we go. Can everybody see the statute of limitations notes there? Okay. So the concern on this one that was identified was that it, at least some people interpret it as a pro attorney provision, a statute of limitations that's protective of attorneys. And that given the newness of the program and our public protection concerns, we might want to consider a more pro-consumer statute of limitations. I have here on the board the full text of the statute of limitations for claims against attorneys. And it's really a two-part statute of limitations. It applies pretty broadly. It's for any action against an attorney for a wrongful act or omission arising out of the performance of their professional services other than an actual fraud claim. And the statute of limitations is either within 1 year after the plaintiff discovers or through the use of reasonable diligence should have discovered the facts constituting the wrongful act or omission, or there's a 4-year cap total from the date of wrongful act or omission, whichever occurs first. It sounds pretty harsh, but there are some plaintiff or consumer protective tolling provisions. Those are here listed 1 through 5. I think the number one, the claim is told, or the statute of limitations is told when the plaintiff has not sustained an actual injury. The test for that is basically as long as an injury occurs if there's a legally cognizable injury. So that usually occurs as soon as the mistake occurs or as soon as some right is waived. So that's not super protective. What is protective of clients, and this came up, this is probably responsive to Kimberly's concern raised last week, is that claims are told while the attorney continues to represent plaintiff regarding that specific subject matter in which the wrongful act or omission occurred. If we applied this to paraprofessionals, then as long as the paraprofessional continues to represent you, your claim is told. And then as Kimberly mentioned, you might then bring your claims, have an attorney take over your case. Well, your statute is only going to start running then. And then if the attorney discovered something that was wrong and advised you have a claim, you would have, that 1 year or 4 year period commencing then. The other tolling for that 4 year limit, that 4 year absolute cap, is that if the attorney or paraprofessional, if we applied it to paraprofessionals, willfully concealed the facts constituting the wrongful act or omission, that would also toll. The additional tolling provisions are for a legal or physical disability for the plaintiff or a dispute while a mandatory fee arbitration is pending between it would be a paraprofessional and the client. If we did not recommend a specific statute of limitations for claims against paraprofessionals, the alternative is a little unclear. It would likely be either 2 or 4 years, depending on how the complaint against the paraprofessional were styled. Most likely it would be 2 years under the Code of Civil Procedure 339, subdivision 1. It's for breach of an oral contract or a tort affecting intangible property. Most negligence claims against, for instance, accountants fall under that 2-year provision. However, a 4-year provision could also apply if they stylized it as a breach of, say, a portion of the fee agreement. Lee versus Hanley, which is a case that Andrew mentioned on our call last week, discusses, and if you want to read more, the citation is up there. 61 Cal 4th 1225 talks a bit about the rationale behind the enactment of the 1-year statutory statute of limitations for attorneys. It was enacted in 1977. The initial impetus was fast rising malpractice insurance rates for attorneys. And the problems were, number one, it was a longer statute of limitations period, but also there was a lack of clarity as to whether what the statute of limitations would be for any given claim. Again, this quoted portion notes that lawsuits for attorney malpractice could be 4 years if the plaintiff pleaded a breach of written contract, 2 years oral contract or tort in affecting intangible property or fraud. So there was a lot of uncertainty. I think that it would be wise, likely, to maybe we'd play with the years, but to use the attorney statute of limitations as a model because it is detailed and it certainly provides clarity for both consumers and the paraprofessional.
Very helpful, Brady. Thank you for that. I think this might be another controversial one, but it sounds like what you're proposing is that we do recommend having a statute, a parallel statute, and just decide if we want it to be 1, 2, 3, or 4 years, and as opposed to having uncertainty that would follow if we didn't recommend a statute at all. And I assume that means that these tolling periods also would be unclear. So without the statute, I think that I do think that this statute provides some clarity that might be lost if we don't do it. I do think there might be an issue with the number of years, especially because there just isn't the track record of claims against paraprofessionals and what the standards are and how our court's going to apply the standards of professional conduct for attorneys in that case law, and we just don't know. So I do think a 1-year statute might be too short. But I do like the idea of what you're suggesting, that it probably does make sense to have some law. And of course, the legislature is gonna need to consider this too.
Certainly.
It's gonna have to be a legislation.
Can I ask you a quick question on disciplinary action? So if the bar is going to take action against the licensee, what's the statute of limitations on that?
I don't know that we've made a recommendation. I'm forgetting what they call it in the state bar rules. For attorneys, it's 5 years.
Oh, it's 5 years. Okay.
And there are various tolling
Yeah.
provisions.
But it might be, for example, to have a successful malpractice claim against a paraprofessional, having some sort of discipline first might be important. These might be cases of first impression if they're brought, hopefully they won't be frequent, but we just don't know what malpractice claims will look like against paraprofessionals.
I like the thought of a longer one. I think you need to put something in to the law, but I do think a longer one is better for the public.
it seems like a general, for instance, a personal injury based on negligence claim is generally also 2 years. So I was trying to make sense of it by looking at numerous cases. It seems like 2 years is the case that is the statute that comes up most often for these sort of general negligence type claims. And that's the sort of the bottom end of what a claim would be in the absence of a specific statute. So, I mean, I could see the basis for arguing that we should use the attorney model, but instead of 1 year, 4 year, make it 2 years, 4 years, or 2 years and no 4-year cap is also a possibility.
I don't have a strong position. I just think that when attorney and client or paraprofessional client become adversaries, they're in the same boat. So if you're going to change the statute of limitations to 2 years, as you just suggested, then it should be the same for a client suing an attorney. I think they're in the same position.
So I agree, there is some benefit to having it parallel. It sort of feels incongruent when they're not parallel. But again, for the paraprofessional program is new, and these paraprofessional clients would have to probably both be injured and then hire an attorney to pursue the paraprofessional, and it's a new area of law. These will be the first claims against paraprofessionals. So it is pretty harsh to have a very narrow statute of limitations, narrower than any of these negligence claims or contract claims or fraud claims out of the gate. So Brady, are you looking for a recommendation now, or are we sort of still?
Well, initially when we started going through these, Leah, and we had and I had a discussion with but the others that we discussed last week were all sort of unanimous, and we didn't do a resolution, and we just said, well, we'll sort of bring it forward as the regulation subcommittee discussed these and agrees that that it makes sense to follow the attorney provisions in those cases. In this, we could have a motion to either any motion based on some permutation of modeling 340.6 to paraprofessionals, whether with some modification on the numbers or not.
So my personal suggestion is this is going to be a controversial one. I think the full working group will probably want to discuss and consider it, and I'm not sure where it will end up. I am comfortable with what I think is your recommendation, which is a parallel statute and just really maybe do the 2 4-year with a 4-year cap or something similar to that.
Plus the tolling that exists for attorneys.
Right, but again, I do think this most of them I predict are not going to be controversial. I think this one might be.
Okay, well, and then maybe we should treat this the same. And what we've come up with is, it definitely makes sense to have a specific statute for clarity and for all the reasons that the attorney statute was developed 45 years ago. But that we're open to discussion. We think there should be discussion on the actual years.
Mm-hmm. I agree with Amos's position as well too. Just because it's the new area of law, this is the opportunity to, make improvements where we know improvements are needed. So if to change it to 2 years makes sense, you've always wanted to do it, why don't we just do it? So if we as a committee are putting forth a recommendation for this, I would agree with what Amos just said.
Okay.
Me too. And kind of to what Fariba had said earlier, I think since we are starting this new program, if there are things that we think attorneys should change, let's start it here and hopefully bring the attorneys up to it too. So I think if we do go 2 years, I think that's kind of a reason why it would be the difference. So again, because of consumer protection.
Okay. In the last area, I don't have a lot more. Let's see, how do I stop this? Screen share again. Oh, can you stop sharing?
Yeah.
Thank you. So the last item was this California Civil Procedure Code 995.510. And that refers to personal sureties and their sufficiency. And basically the provision is here, 995.510A. A personal surety on a bond is sufficient if all of the following conditions are satisfied. Surety is a person other than the principal, no officer of the court or member of the state bar shall act as a surety. Then some other requirements that it be a resident of the state, neither a owner of real property or a householder, and a requirement that the surety have a certain net worth sufficient to cover the obligation. This applies to any bond or undertaking required by statute. It comes up in, for instance, bonds to state judgments pending appeal. The requirement that a surety not be an officer of the court or member of the state bar does appear on judicial counsel forms for sureties. However, this was passed in, legislation was passed in 1982. Haven't online been able to locate the legislative history or any description of it. I don't know that this rises to the level of spending hundreds of dollars to pay for a private search. We could look into that if you think it's important. But I did want to point out also that our rule of professional conduct 1.8.5 on our recommended rules, and I will just read that. Provides that a licensed paraprofessional shall not directly or indirectly pay or agree to pay, guarantee or represent that the licensed paraprofessional will pay the personal or business expenses of a prospective or existing client. There are some exceptions. One is for paying the costs of prosecuting or defending a claim of action or otherwise protecting or promoting the interests of an indigent person in a matter in which the licensed paraprofessional represents the client. Back in 1981, COPRAC issued an opinion which said that setting aside whether other laws allow that under that ethics rule, a paraprofessional would be allowed to serve as a surety or help post a bond to stay a judgment pending appeal, because that would be in the interest of the client. If it was large enough, they would be required to get an informed consent to do so. But I guess what I'm saying here is that through our proposed rule 1.8.5, we've sort of dealt with this issue as a matter of a licensed paraprofessional's ethical duties with respect to his client. And from my perspective, I don't know for this program why or whether we would need to take a position on this CCP ban on attorneys in general serving as sureties. I think that might be one that we could leave up to the legislature and just flag for them.
Sorry, is this something we already discussed at the last one? Because do you have the rule for attorneys, what the prohibition is for attorneys?
Yes, is it still, it's funny, I can't see what I'm actually displaying. Do I have the surety notes still up there being shared?
Yeah, it's on there.
So this is the prohibition for attorneys.
Are you able to make that any bigger? It's kind of hard to read.
Sure. I think so.
So A1 says the surety is a person other than the principal. No officer of the court or member of the state bar shall act as a surety. So I guess the first question is, would that cover paraprofessionals or not? Would a paraprofessional be an officer of the court or member of the state bar?
This is a place where member has not been replaced. I thought we went through all the statutes and replaced member with licensee. Guess we missed this one.
I think that I think in Business and Professions Code 6001, there's a provision that states that every reference to member, but I believe that's only the Business and Professions Code. So
But
phrase member of the state bar actually still appears in the California Constitution, although we don't consider our licensees members any longer.
so whether this is member or licensee, in other words, if there's a catch-all somewhere that would reinterpret this to be licensee, there's still the open question of, does that prohibit paraprofessionals from serving as a surety under the existing law, right?
Yeah, and I that's a good point, and I don't know the officer of the court, member of the state bar, generally understood to refer to a licensee attorney. I think if you looked at what was meant when any of these statutes were enacted, they mean an attorney because there were no paraprofessional licensees. But officer of the court, I don't know that that's a term of art that could include paraprofessionals. But I guess I'm interested in your take on the sort of the larger philosophical question on whether this is something where we need to make a recommendation to stand up the program.
And I think last time, just from, I think we talked to both Andrew and Randy, neither of them had ever even heard of, right, of this kind of occurring. So it's almost like it's super old. So maybe we just keep it the same, right, for paraprofessionals, just.
It's a bit obscure, and you know, we have a whole suite of sort of references to attorney where we're going to tell the legislature, hey, you know, we don't see any reason to treat paraprofessionals differently.
Yeah, I agree with that.
Me too.
Okay. Great. Well, that's all I have. I'll have more quantitative and hopefully a little better description of the process on the MCLE issue. Although again, it sounds like seems like the evidence will lead us toward a recommendation not to have that open-ended rule for paraprofessionals, and there may be one or two other issues to bring up next week, but hopefully we're getting to a close on these open issues. Is that it, Linda?
Yeah, I don't have anything else. Does anyone else think that we have anything hanging that needs to be resolved before, especially before our meeting on Monday?
Linda, I have one additional question on the governance structure.
Mhm.
Going back to that. So I
Let
just
me-
went back and looked at my notes. In addition to the size and membership of the oversight board, I had raised a question about the hearing panel selection. That was the one division of labor. I think in the staff memo, it suggested that the hearing panel selection, so this would be the disciplinary hearing panel, instead of being selected by the oversight board, that it would be recommended by the board to the state bar board of trustees. And that seemed odd to me. I think Leah mentioned that might relate to the payment for services or something like that. But for me, it makes sense for the oversight committee to be selecting the hearing panel. So I just wanted to at least open that up for discussion or remind of that issue. I guess that's a question to you, Linda. Was there any further thinking about?
I think we haven't looked into this any further since that was raised.
I can't remember. I mean, I haven't looked at my notes on the discipline committee for a while, but I thought that was our recommendation. Wasn't it, Linda, that's who would choose it? And maybe it got changed though when it was all put together.
Right. How is that done with the DCA boards? How are those hearing panels selected?
So we don't have hearing panel because
see.
we use the Office of Administrative
Oh,
Law.
that's right. Okay,
And so it's an administrative law judge who's just one of their judges assigned to it. And then the board itself then hears that second. It's not sent to any hearing officer. The board looks at it.
Can I just clarify, Kim, when you say that was our recommendation, what do you mean?
I think it was our recommendation that it be chosen by the board,
Right.
who those hearing individuals would be. I don't have my notes right here with me, but I believe it's been a while since we've met, but I think that's what our recommendation was.
So maybe Linda, this can be just something that you take back and look into, because I think that was the division of labor otherwise made sense to me. That was the
Okay.
one that stood out, and it sounds like the discipline committee also
Mhm.
made a recommendation there.
okay.
I had a question about Monday's presentation. So is anyone taking a lead for our presentation? I need specifics. So we have the consent calendar, I guess. Is somebody putting those forward, calling for a vote? Who's doing that? And are we handing it to each other? What am I expected to do? It's all about me.
Happy to
This is
hand-
Joanna. I mean, normally the chair of whatever subgroup is presenting is the one to be presenting.
I
So
know.
really, it's up to you all. We will be looking to you, Fariba, unless there has been a discussion within the group. I can see why you might want to divvy some of this up, and you don't have to do it as part of this. You can, decide offline, but, just to basically decide amongst yourselves, and you can do it right now if you want, who's going to take lead on what. But I completely agree with Fariba that needs to be understood before the meeting begins on Monday.
Yeah, and the thing with this committee is we don't have a chair, but but I think she just appointed me chair. Does
Yeah.
that come with a paycheck? So do we need to do it now, or can we communicate it with Linda separately so we don't violate?
I think the tricky part is Greg is probably going to do a lot of the heavy lifting.
Yes.
So I think we're fine, Fariba, with you focusing on the rules that you agreed to take on. And I'm happy to sort of take a broader overview on the generalized stuff. But again, I'm hoping Greg is really the expert and has put a lot of work in. So I'm hoping he's
Right.
And the consent items are first, right?
Yes.
I think where it's gonna come in, so I think what we had talked about was Greg was gonna present them, right? And so he would, present, and if anybody pulls them off, I think that's where we're gonna have to be ready to explain why, as a subcommittee, why we put any language in on any of the ones that they pull off. I think that's where we have to be kind of prepared.
Right.
Okay.
And I can send out that email this afternoon, reminding people that they will have the option to pull a rule off pull it out for an individual vote.
Okay.
All right.
All right. Thank you.
And then we present each one of our own and then hopefully make a motion and then move it from there.
This is going to go very smoothly.
It
Oh,
is, absolutely.
Or at least it will be exciting.
Yeah.
Thank you.
Great. Well, thank you. Is there anything else? All right. Well, great. We get to end a little early. We'll see you
Thank you,
all on
Linda.
Monday. Okay.
Bye, everybody.
Bye.